Hello, my name is Jordan Walker. I'm an attorney with the law firm of Seaver Walker Paget. Today we'll be having a webinar on the State Road 92 project, Paulding County. And with that being said, we're going to go ahead and get started. Again, I'm with the law firm of Seaver Walker Paget. We are an eminent domain only, landowner only law firm located in Alpharetta, Georgia. We are, as I said, eminent domain only attorneys. This is the only area of practice that we do. I am licensed in Indiana, Illinois, Texas, Georgia, and Missouri. This is the only type of law I've ever done. And as a consequence, our firm and myself, we've accrued quite a bit of knowledge about eminent domain, what to do when the DOT wants your land for a road project. And our goal here today is relay our education, share with you the law, what happens in an eminent domain acquisition. We're going to talk about the project a little bit as well. And I do want to stress that we are not with the Georgia Department of Transportation. We are a landowner only law firm. We only represent landowners. The State Road 92 project is a GDOT project that would widen, reconstruct State Road 92 from Hiram Acworth Highway to US 41 Cobb Parkway. It's going to widen from a 2 to 4 lane road. You can see a picture of the project limits there, a map there on the right. It's approximately 6 to 8 miles in length, and land acquisition is underway. Construction is planned on this project for this year and next. Eminent domain. Eminent domain is the ability of GDOT in the state of Georgia to acquire private land and set it to a public use, public purpose. In this case, it would be the State Road 92 project that would fit that public use. In other words, they have the ability to take private land and set it to a public use. Road projects are the most common exercise of eminent domain in the state of Georgia. So while they have the ability to acquire this land, whether landowners would want to happen or not, or would refuse otherwise, it doesn't matter. Ultimately, they have the ability to take it, but they also have to pay what's referred to as just compensation for the land. This is guaranteed by the Fifth Amendment, and a landowner is entitled to just compensation. What that ultimately means is that if it gets to that point, the landowner has the ability to present evidence in front of a jury and allow the jury to determine just compensation owed because of the acquisition. GDOT has inherent eminent domain authority, which means it's not delegated by anyone else. They have the ability to file eminent domain lawsuits as a matter of right. But while they do have the ability to do that, there are pre-condemnation, pre-eminent domain requirements that they must meet prior to initiating a condemnation action against a landowner to take their land. This is the process for eminent domain in the state of Georgia. And I mentioned the pre-condemnation requirements, the pre-eminent domain requirements. One of them is that they have to inspect the property that is to be acquired, them being the appraiser. So GDOT's appraiser, who will create an appraisal and then which forms the basis for an offer of compensation to the landowner ahead of the eminent domain lawsuit. Prior to all that happening, they have to inspect the property and they must allow the landowner to be present during the inspection of the property. This means that when the appraiser comes out to look at your property, they must give you advance notice. They must notify you that it's happening so that you have the opportunity to be present. Another requirement is that they need to issue an offer to the landowner prior to eminent domain. So we talked about the appraisal. The appraisal is done, and then the offer is issued that's based on that appraisal to the landowner. This has to be done. But beyond that, as part of that offer, GDOT must provide a meaningful summary of the appraisal to the landowner, at least. Meaning they can't just say this is the appraisal number. It needs to supply information to the landowner such that they can meaningfully evaluate the offer being presented. Those are two pre-condemnation requirements that GDOT must meet prior to eminent domain prior to filing an eminent domain action. Ultimately, if after the offer is issued and negotiations break down and a deal cannot be reached between the landowner and GDOT, they have the ability to file what's referred to as a condemnation petition. This is litigation. This is eminent domain, so to speak. Condemnation is the process by which eminent domain is exercised. So if they filed a lawsuit against you for your property to take it, it would be called a condemnation petition. It's important to note that a landowner, if they wish to contest the compensation being offered by GDOT, needs to file a notice of appeal within 30 days of being served the condemnation petition. If they do not file a notice of appeal within 30 days of being served the condemnation petition, the case is effectively over and the landowner receives the offer initially offered by the Georgia Department of Transportation. If a landowner files a notice of appeal within 30 days, a timely one, the case moves on, ultimately ending up at a jury trial if it gets to that point where parties present evidence as to compensation and the jury renders a verdict. These are some components of compensation that are compensable in the state of Georgia for landowners. First, for partial acquisitions. Partial acquisitions are when a acquisition only involves a part of the entirety of the property. Meaning if you have a 4-acre tract and they're taking 1 acre, that is a partial acquisition. So for every partial acquisition, the landowner is entitled to the value of the property to be acquired. So they are entitled to a proper price per acre based on the land value of the property. And that can also be based on what's referred to as a highest and best use. Highest and best use is the highest and most economically beneficial use that property can be put to that returns the most value. An example of this would be if a landowner's piece of property is being used as a residence, but it is a otherwise commercial property, and if it were to sell onto the commercial market or on the open market, it would sell as commercial property. If that were the case, the property could be valued as commercial land as opposed to residential land. Another component of compensation on partial acquisition is remainder damage. And remainder damage, if it exists, can be caused by any number of different aspects of a partial acquisition. Remainder damage refers to the damage that the acquisition has on the rest of the parcel. So going back to the 4-acre example, if GDOT's taking 1 acre, how does that 1 acre impact the remaining 3 acres? These are some examples of how remainder damage can exist for residential property. Setback loss. If a house is closer to the road than it previously was, the house can potentially lose value. That would be an example of remainder damage. Ordinance noncompliance. If an acquisition causes your property to be non-compliant with local zoning or ordinance rules, that also could have an impact on the remainder of the property. Examples of commercial remainder damage include the same aspects: ordinance noncompliance, access limitation. If a property's access is being taken away, that can have an impact. If it becomes less visible, if the parking is reduced, if the lot is reduced by size such that it can't be developed anymore. All of these are all examples of how remainder damage can reveal itself in a partial taking, in a partial acquisition. And then finally, business losses. If a partial acquisition destroys the value of the property located on the property, then whoever's sustaining the loss, whether it be the landlord or the tenant, whoever owns the business, can potentially recover the lost business caused by the acquisition. And then for total acquisitions, there are very similar components that are available to landowners, components of just compensation. The first aspect, something we already touched on, that being the price per acre and the highest best use. The same rules apply on partial acquisitions that they do on total acquisitions. Business losses, again, the same rule applies. If you can demonstrate that the business is destroyed on the subject property and it cannot be relocated elsewhere, whoever's business is being destroyed can potentially recover business losses. And then finally, one different component for total takings versus partial takings are relocation benefits. If a property is being taken and there's a home on the property and the home is being taken, or the business is being taken on a commercial property, then not only are you entitled to the aforementioned aspects of compensation, you're also entitled to relocation benefits, which is effectively compensation to allow either the business or the residents to relocate from the subject somewhere else. A residential relocation includes moving expenses and a differential payment. A differential payment effectively means the difference between the value of your home and the available homes on the market of similar properties. Those are the majority of the relocation benefits. There are some other small benefits as well, including mortgage assistance and other issues. If you're a tenant, you can be entitled to tenant relocation benefits expenses. Those are separate apart from a homeowner having to relocate. And then commercial, the big difference is between residential and commercial is that commercial business owners are not entitled to differential payments to purchase new business property. They are entitled to moving expenses, and they are entitled to reestablishment expenses, that being costs to reestablish the business at another location. And then just talking generally about attorneys and hiring attorneys, if you are a landowner who is interested in hiring an attorney eventually for this case, there are many different types of arrangements between attorneys and landowners on eminent domain cases. The most common arrangement between landowners and attorneys are contingency fee agreements, where the fee that the attorney recovers is contingent on what they can do for you. Generally, a contingency fee is contingent on how much more the attorney can get for the landowner in the form of compensation. Generally, in a contingency fee agreement, there are no upfront costs, there are no retainer fees. Generally, no money is exchanged until the end of the case. And this allows landowners to hire attorneys without coming out of pocket. Another common type of arrangement between landowners and attorneys are billable rates or hourly rates, where an attorney bills a landowner for the work that they put in on the case. Oftentimes, this will require an upfront retainer that the landowner pays to secure the attorney's representation, and then the attorney bills back against that retainer at their hourly rate until the retainer has run out. An example would be if you wanted to hire an attorney and they had a $5,000 retainer, for example, and you would then pay the $5,000 up front, and then the attorney would bill against that $5,000 in whatever their billable rate was. Let's say it's $500. That would effectively secure the landowner 10 hours of the attorney's work, and then if further work would be required, they'd have to replenish the retainer or potentially just pay on the hourly basis after that, depending on what the agreement is with the attorney. These are just some examples of attorney-client relationships in eminent domain cases. And with that, I will end this presentation. I don't see any questions, so thank you for attending. I appreciate it, and hopefully you learned something.